financial problems, elder law, tax problems, business matters, divorce, personal injury, bankruptcy, your life, your reality. Life is complicated. There is the law and there is reality. Welcome to Law and Reality, sponsored by Thav Gross. Now here's your host, Ken Gross.
Hi, welcome to this segment of Law and Reality. This segment is going to be a fun one, something that I've wanted to cover on the show for a long time. I've got Brian Small with me, David Einstandig. We're going to cover the topic of contracts. It's going to be a lesson on contracts. It's not financial crisis. It's not Medicaid planning. I want to just take the topic of contracts and have some fun with it. Part of this expansion of the area and the topics that we're covering at Law and Reality.
One of my favorite topics in law school, right up there with constitutional law. Not so much.
Well, I don't really think that in law school, I don't remember first being a 1L in law school taking bankruptcy or financial crisis. I mean, you took contracts, you took civil procedure, you took real property. Contracts.
Yeah, law school didn't get to be fun until the third year, so that's okay.
Did you watch the movie Paper Chase, or are you too young?
I have seen the movie Paper Chase.
The whole essence of law school was the contracts case. It was the contracts class. That was the number one class. That's where lawyers are made. Because I was a contracts guy. Anyway, here's why I want to talk about it. Contracts are everywhere. We have contracts that arise between parent and child in terms of the parent says to the child, I'll get you a toy if you clean up your room. Okay, that's a contract. You walk into McDonald's and you order a burger and fries. That's a contract that is arising as you go. Everything we do is based upon contracts.
Ken,
not everything's a lawsuit, but contracts are everywhere.
Do you know, Ken, that right now the largest question among I guess I don't know what generation the younger kids are, but my kids and whatnot, and most people in the world is contract-based. Do you know what that question is?
No.
They want to know how far along they're in their contract for their cell phone as to whether or not they're in the upgrade stage.
I think you're absolutely right. There you go. You've got that. That's a contract. Contracts arise and you're not even thinking about them. You get satellite TV and you're locked in forever, and then you find out as soon as you ask for another receiver, you're automatically signing up for another 2 years. It's like they're perpetual contracts. But the whole thing.
What about the gym?
The gym's another contract. They're everywhere. What's fun about the topic is taking the time to understand what the elements and the rules are relating to contracts, so then sometimes you can evaluate those rules in the context of everyday life. And that's what I want to do. Now, there are three elements, classic elements to a contract: offer, acceptance, and consideration.
You have to be polite? Is that what you're saying?
No, you'll see. You don't have to. You can be rude at times, but you have to have all three elements. Let's talk about offer and acceptance first. Now, offer creates what we call the power of acceptance. It's defining and inviting someone to enter into a contractual relationship in such a way that you're creating to the person you're speaking to or dealing with, the offeree, the power to accept. Now, the best way to understand it sometimes is by way of example and by way of examining what is not an offer. And the classic issue comes down to an advertisement. And the issue is an advertisement an offer to contract, or is it an invitation to deal, which would be in effect an invitation to receive an offer? I'll give you an example. I'm a car dealer. I run an ad. We see them all the time on the paper. And I say I have 2015 Chevrolet Corvette, $20,000.
It's a great deal. Sign me up.
Okay, if that's an offer, and you call up or you send a letter back to the dealer saying, I accept the offer, then we'd have a contract. But here's the problem. You run that ad in the paper. What if 20,000 people instantly called up or sent an email back saying we accept the offer, and the dealer only has 2 Corvettes? He would be able to honor 2 contracts, and he'd be in breach of the other 20,000 people accepted?
Mm-hmm.
He'd be in breach of the other 19,980 contracts.
He better hurry up and order some more supply from the
Well, that would be one response.
manufacturer.
But the way the law interprets that is they say, generally speaking, an advertisement is not an offer, it's an invitation to deal. So if you then called up and said, I'll take the car, then you're making the offer to buy the car, and if the dealer says, I accept, then you would have a contract. Now, with every rule in contract law, there's also exceptions to the rule. There's a classic case, I don't remember what it was, but the 3 of us covered it in law school.
Rose the Barren Cow.
Where if you specified all of the elements of the particular advertisement so that it was one and only Rose the Bearing Cow, so that you didn't have the quantity problem, then that advertisement could be construed to be an offer.
Well, actually, in the advertisement, Ken, most advertisements today that are commercially done always have the tagline while quantities
are
last.
limited.
But
while
I want to get
supplies
back.
are
I want to get
limited
back to
or
basics
available.
real quickly. Is what you're talking about. What it boils down to, and you said we talk about elements as a legal perspective: offer, acceptance, consideration. You can also think of it as you have to have what they call a meeting of the minds, a mutual assent. So when that car dealer is doing that advertisement, he's not saying every single person that sends in an acceptance is going to get a car.
Because that's not his intent.
But that's just right. So if you have to have a mutual assent that both parties understand the material terms of what they want to
that they're
do,
intending a contract.
and they have this, they're on the same page.
Mutual assent is the bubble over offer and acceptance that you have to evaluate it in. All right, so rule number 1, generally advertisements are invitations to receive offers. Now let's talk about acceptance. Acceptance is communication to accept the terms of the offer and intend to be contractually bound. Now, the next thing you come into is what's the manner of acceptance? The rule is you have to, if the offer specifies the mode of acceptance, you must comply 100% with the offer. If the offer doesn't spell out how you accept the contract, any manner reasonable in the circumstance. I'm going to give you an example. To David, I will sell you my car for $2,000 cash, but you must push a peanut from first to second base along the infield of Comerica Park during a Tiger game to accept. The question is, how do you accept that contract that I just made as you an offer?
Push that peanut.
That's the only way of doing it because I specified the mode. We'll be back after the break.
Carrying too much debt? Resolve your debt. Call Thav Gross.
You don't need to be broke, and you don't need to hit rock bottom. If you have income and you're struggling with debt, dump it. Think about the next 10 or 20 years. If you do what the banks tell you, you'll have nothing to retire with. There is a solution.
Don't waste your future. Call Thav Gross. We're experts at eliminating credit card debt. 888-235-HELP. That's 888-235-HELP.
Every family has the family meeting, and we all know what that means. Dad's got dementia. What are we going to do? What's the care plan that the family has in place? Usually they don't, or they struggle with a care plan. When you go home tonight and you talk to your tax person and you talk to your financial person, say, what's the plan that you have in place? And as soon as they don't give you an answer, give me a call, because I can do it for you.
Tax problems are major problems. Don't let the IRS levy your wages and seize your assets. There is a solution.
We're Thav Gross. Our firm will solve your problem.
If you're behind on your taxes and owe money to the IRS, call Thav Gross.
We've been solving tax problems for 32 years. We stop wage levies, resolve unfiled returns, and obtain the best possible settlements.
Call Thav Gross today, 888-235-HELP.
A lifetime of hard work. If you don't have the right plan in place, you can lose your home, your savings, and more. And you didn't come this far to lose everything. Samasco Law wants you to know that laws are changing. Today, the average cost of nursing home care is $85,000 a year. With proper planning, we can help protect your life savings and get you the Medicaid and nursing home benefits you deserve.
How much can you afford to lose? Call Samasco Law today.
It's devastating, the effects of debt and foreclosure on you and your family. There is a solution.
Worth Ave Gross, our firm will solve your problem.
Some fear the word bankruptcy, but in reality, it's a strategy to save your home and to eliminate debt. If you're in financial trouble, timing is critical. You need to take action now. We've been saving homes and eliminating debt for over 33 years.
Call Fav Gross, 888-235-HELP.
Welcome back. All right, we're doing a lesson on contract law. Before we do it, I want to do announcements quickly. We have a seminar coming up Tuesday, February 24th. It is called It's Time to End Debt Now. The key to preserving future income is making sure you've minimized your debt. If you're sitting on $50,000 of credit card debt at 20% interest, paying $10,000 a year of interest, and you have to make $15,000 in order to pay your taxes so you net the $10,000 to give to the credit card company, you're probably spending 15 to 20% of your gross income on interest alone. I can tell you there's one word to define that: insanity. There's also one result that will come out of it: you'll be broke. If you want to be smart, you don't listen to the credit card companies. You don't listen to the advertisements that make you think that the most important thing in your life is your FICO score. I'm telling you right now, the most important thing in your life is to get rid of that debt and start saving that $1,000 a month you're giving to the credit card companies for interest, and instead putting it in the bank so you've got something to retire with. You want to learn how to do it? You go to our free seminar. It is on February 24th. That's a Tuesday from 7 to 8:30 p.m. To get there, to sign up, you go to thavgross.com or lawandreality.com, or you can call 888-235-HELP. Want to thank Samasco Law and Thav Gross as our sponsors. Now back to contract law. So in my example, just like you said, David, the only way to accept that offer was to push the peanut across the floor because I specified the mode of acceptance. Now I want to jump into what I consider to be the most fun aspect of analyzing contracts.
And if I got
maybe I will. Jump.
If I got 3 inches to second base, and I ate the peanut because I got hungry,
you lose. No soup for you.
So there's no such thing as partial acceptance.
No, you got partial acceptance would be a counter. We'll just go right off. Right, it's a good lead-in. If the acceptance modifies the terms of the offer, it is not an acceptance, it's a counteroffer. There's one exception to that under the Uniform Commercial Code involving contracts involving the sale of goods between merchants. There's a way where you can modify the acceptance from the offer and still generate a contract. It is a issue in law school that you spend somewhere between 4 and 6 weeks on that one particular issue.
Let's just say it's
so
beyond the scope. Beyond the scope of the show at this point.
Beyond the scope of reality is what it is. But the general rule is if you modify the offer at all, it is a counteroffer. Now, when you make a counteroffer, that creates a new power of acceptance going back to the person you've made the counteroffer to.
And at the moment that you make that counteroffer, the old negotiations are done. You can't go back because a counteroffer is 2 things, Ken. It's an offer, but it's also a simultaneous rejection.
So you're saying when I sold my house.
No, let me give you an example. I'll do it right with you right now. Okay, now it's just me to you, Brian. I will sell you my car for $2,500 cash. I've made an offer.
I don't think so.
Suppose you say to me, read the outline.
I read the outline.
Your car
has scratches on it. I'm only going to give you $2,400.
That pisses me off. Number one, that you said that, but it's a rejection.
No, really, it does have scratches.
You've insulted me. You've rejected me. You rejected my offer, but at the same time, you've now made a counter offer at $2,400.
It's worth about $2,400.
I respond to you, forget it. Well, when I respond to you, forget it, I'm rejecting your offer, going back to what you said, David, but I have not made another counteroffer.
But I want the car.
Our deal is dead. Now you come back and say to me, okay, I'll give you the $2,500 because you're a baby. That is not that's an offer because I already rejected your previous offer of a counter offer. So now you've offered to buy the car from me for $2,500. I respond to you by saying, too late, buddy. It's $2,700 if you want the car. That's a rejection of your offer at $2,500 and a counter offer at $2,700.
Are you crazy?
You say to me, "Am I that? How do we interpret? Are you crazy?" That I would call as an insult. I don't know that that's a rejection. You might argue that it's a rejection.
So that's why
when
I said consideration, do you have to be polite? You don't have to be
right,
polite
you
in this
can
communication.
Be nasty. So let's assuming "are you crazy" is an insult. I then say to you, "Okay, we now have a deal at $2,700. That would be an acceptance."
Yeah, I'd have to accept it. But here's my question.
No, I'm accepting it.
Okay, so you
I said to you, "I'll too late, 27." Oh, no, you're right. You have to say to me, "Okay."
So I say, okay. Now I buy the car for I've agreed to buy the car for $2,700. What if the car doesn't run?
Whole different issue.
That's Rose the Barren Cow.
The generally accepted assumption in that situation is I'm selling you a car. It's a good. It's a movable item. The Uniform Commercial Code actually kicks into play, and it says that it has to be merchantable. It has to be in ordinary working condition.
Does that apply to individuals that are like, I go buy a car on Craigslist, or is that only a dealership?
You still have an implied warranty of merchantability regardless of whether it's made. I don't think it has to be made by a merchant, if I recall correctly.
Correct.
So that would be the case. All right, now, when is the offer and the acceptance effective? Now we have another issue. We've been going back and forth verbally. And the general rule is in a verbal communication, an offer will exist and stay open until it lapses, which is the end of a conversation.
So you're talking about, are there takebacks?
Yeah. When can you change your mind? And here are the rules. First of all, an offer is revocable any time before it is accepted, unless it's an irrevocable offer. And I'll tell you in a second, there's two types of irrevocable offers. Now, when you revoke an offer, which means you take it back, or you reject an offer, like when we did our insult, the rejection and the revocation is effective when it's received, when the person receives the communication.
So you're saying, by that example, hang on.
Okay.
Too late is $2,700 to you. And you're about to say, okay, and I can see you're thinking and you go, well, I think I'll, and I go, no, forget it.
Perfectly fine. You have the right
before you say okay.
Because you've communicated the revocation and it was not an irrevocable offer. That is correct. Acceptance, if you're dealing with faxes and emails and letters, is effective when sent. So you have an interesting thing. It's called the mailbox rule. When you stick the acceptance in the mailbox, you have a contract because you can't revoke once the acceptance is effective.
Is that applicable that's applicable for something that goes in the mail? Is it applicable for a fax, which is time-stamped, or an email that's time-stamped?
Yes, it would be. You run into interesting issues over the phone versus what is going back and forth and being sent. Two types of irrevocable offers: an option contract, which is a contract to make an irrevocable offer, and you also have an irrevocable offer in the context of merchants' firms' offers under the Uniform Commercial Code. We'll be back right after the break.
It's devastating, the effects of debt and foreclosure on you and your family. There is a solution.
Worth Ave Gross, our firm will solve your problem.
Some fear the word bankruptcy, but in reality, it's a strategy to save your home and to eliminate debt. If you're in financial trouble, timing is critical. You need to take action now. We've been saving homes and eliminating debt for over 33 years.
Call Fav Gross 888-235-HELP.
A lifetime of hard work. If you're approaching retirement and don't have the right plan in place, you can lose your home, your investments, and your savings. And you didn't come this far to lose everything. Putting a solid strategy in place with Simasco Law legally protects your assets as well as your wishes. Since a will doesn't cover you medically or financially, Simasco Law goes beyond ordinary asset management protection to safeguard everything you have.
How much can you afford to lose? Call Simasco Law today.
Carrying too much debt? Resolve your debt. Call Thav Gross.
You don't need to be broke, and you don't need to hit rock bottom. If you have income and you're struggling with debt, dump it. Think about the next 10 or 20 years. If you do what the banks tell you, you'll have nothing to retire with. There is a solution.
Don't waste your future. Call Thav Gross. We're experts at eliminating credit card debt. 888-235-HELP. That's 888-235-HELP. Tax problems are major problems. Don't let the IRS levy your wages and seize your assets. There is a solution.
We're Thav Gross. Our firm will solve your problem.
If you're behind on your taxes and owe money to the IRS, call Thav Gross.
We've been solving tax problems for 32 years. We stop wage levies, resolve unfiled returns, and obtain the best possible settlements.
Call Thav Gross today, 888-235-HELP.
All right, welcome back. I don't want to waste the time on going into irrevocable offers. Just to cover it by saying our examples are not irrevocable offers. The merchant's firm offer is between merchants involving the sale of goods. It's a way of creating an irrevocable offer even though there is no consideration. All right, let me give you an example, and it kind of goes to what we were talking before. Me to Brian, I will sell you this antique pen that was used by several presidents for $2,000 cash. You have until Monday to decide. So I've said to him right off the bat, it's Saturday or it's Sunday, you have 24 hours to decide. Most people would think that at that point, Brian has until Monday to decide. But if I decide an hour later after the show, I call him up and I say to him, Brian, I revoke my offer.
But I want the pen.
And Brian says, I want the pen. Too late. I had the right to revoke because Indian giving is okay in contract law in the context of offers. You can make an offer, you can say it'll be held open for a specified period of time, but you still have the right to revoke it unless it was an irrevocable offer. Now here's the exception. If I said to Brian, $2,000, you have until Monday to decide, and Brian says, Ken, you know what? I really am interested in the pen. I'll give you $5 to make that offer irrevocable so that I'm sure I have until Monday to decide. And he gives me $5 for the option contract to buy that pen at the price of $2,000 anytime till Monday. If I call him up an hour later and say I revoke, he says, you can't revoke. You made an irrevocable offer. That's why I gave you the $5. That's an option contract.
What if the offer is $2,000 and I'll give you Monday to decide and it's irrevocable?
Doesn't matter. What you say, it doesn't. Saying it's irrevocable does not make it irrevocable.
So there's got to be an element.
You might have a promissory estoppel argument later. But
there's got to be an element of consideration to make it an irrevocable offer,
unless it's a merchant's firm offer. All right, now
let's
move on.
Wait a minute.
No, we're running out of time.
Under your scenario, every one of those purchase agreements that you get from the broker for your house that says it's irrevocable for 24 hours is not
correct. That's 100% correct. And you see that and I'm glad you mentioned that because for if you're out there listening or watching, buying a house is a big event and it's a big item and it's a purchase agreement and it's a contract and all of these rules apply. And people don't know the rules. That's why the lawyers get involved when disputes arise. Consideration is the third element. Consideration is a bargain for exchange. On both sides of the contract, each party must have a benefit, something good to them, which we call the benefit, and something bad to them, which we call the detriment. If it exists on both sides for both parties, you have consideration. Example, father to daughter, I will buy you a new car if you refrain or quit smoking for 1 year. Is there consideration?
Absolutely.
For the father, he receives the satisfaction that the daughter does not smoke. That's his benefit.
So it doesn't have to be monetary consideration.
It does not have to be monetary. His detriment is he has to pay for the car. For the daughter, her benefit is obviously the car. Her detriment is she's refrained from smoking, something that she apparently wants to do for some stupid reason. A lease. I'll give you another one. Kids going to college. This one happened to me. I remember it. Daughter goes to college. Second year, she's signing up for, or first year, she's signing up to lease an apartment for the second year. She signs the lease with the landlord. Landlord signs, daughter signs, and then the landlord calls her up and says, we have to have your father guarantee the lease. Well, at that situation, I'm sitting there saying, why should I guarantee the lease? But if I don't, he's not going to lease her the house. He's not going to let her move in. Well, I sign the guarantee afterwards. Now, the question is, the guarantee is a contract as well.
What did you get for it?
I got nothing. Because the detriment to me is I could be forced to pay on the guarantee, but the benefit to me isn't that the landlord signed the lease, because he had already signed the lease the day before. Therefore, if I sign that guarantee after the landlord already agreed to the lease with the daughter, my guarantee is not supported by consideration, and if I'm called upon to pay down the road, I would have a defense. It's an interesting one. I'll give you another one. We're running out of time. Charitable subscriptions. I call up and donate $1,000 to save the children. The benefit to me, satisfaction of giving. The detriment to me, parting with $1,000. To the charity, the benefit, receiving $1,000. But what's missing? No detriment to the charity. A charitable subscription does not meet the consideration requirement. But we have a rule. We have a rule that says charitable subscriptions are enforceable without consideration as a matter of public policy. Why? We don't want people welching on their charitable subscriptions.
Makes sense.
Makes sense?
I would argue that the charity is reliant upon those for its existence, and there could be a detriment if it didn't get the money, notwithstanding the public policy.
There's a necessity there. All right, pre-existing legal duty is the last one I think we've got time for. If you already owe the legal duty, then you are incurring no detriment in the performance of it. Example, police officer, suppose there's a reward out for the arrest and apprehension of a criminal. If a cop goes and arrests the person, the cop does not get to claim the reward. Why? Because he has a pre-existing legal duty as a police officer to apprehend criminals. Like that one?
Even if real quickly, even if you have an existing contract and I'm going to pay you $1,000 to do something, if I then say I'm going to pay you $1,500, but I don't change any of what you're already obligated to do, I think you've got an issue with that amendment and enforcing it. You may be stuck with $1,000 because there's no additional obligations.
We may have to address that in the next show. I'm going to leave you with one last point on contracts. The general rule is you do not need a writing. You only need a writing if a statute of fraud applies, and the next time we cover contracts, we'll talk about it. Thanks for listening and watching.